When Judge Gleason wrote the op-ed for the Washington Post to the effect that the Flynn case is not over until the judge says it's over, Judge Sullivan was listening attentively. Viva Frei, Montreal litigator turned YouTuber, and this is just the never-ending story Law and Order version. I would rather be fishing. I would rather be fishing than doing this, but I have to do this. Now, for those of you who have been living under a judicial rock, Judge Emmett Sullivan is the judge in the Michael Flynn judicial saga who just had his tushy handed to him by the Court of Appeal, so to speak. The Court of Appeal, in a split 2-1 decision, granted Michael Flynn's petition for writ of mandamus, ordering Judge Emmett Sullivan to grant the Department of Justice's motion to dismiss of the charges against Michael Flynn. Try to say that 5 times in a row. Now, to say the majority opinion was not kind to Judge Sullivan would be an understatement. For those who have not yet seen my vlog on the subject, I did a vlog breaking it down. I'm going to link that video right here. Give it a watch if you have not already seen it. Suffice to say, the Court of Appeal decision was not kind to Judge Emmett Sullivan. It ordered him to grant the Department of Justice's motion to dismiss. It did not reassign the case to another judge. They were kind on Judge Sullivan in that sense, but they were not kind to him on the substance of Judge Sullivan's conduct. Even before the Court of Appeal came down with their decision, a lot of people both on the left and the right were somewhat shocked by Judge Sullivan's conduct to begin with in this file. After the Court of Appeal came down with their ruling, most people thought it would finally end there. Judge Sullivan would do what he ought to have done from the very beginning, but he didn't quite do that. Some people call Judge Sullivan a great judge who is following the law. Others call Judge Sullivan a political hack. I am just going to call Judge Sullivan the Terminator. I'm going to call him the Terminator because he just doesn't give up. This is like Arnold Schwarzenegger's half body at the end of the movie, crawling along just trying to finish the job that he can't get done. The Court of Appeal came down with a scathing split 2-1 decision. What does Judge Emmett Sullivan do? He filed a petition for rehearing en banc, meaning before the entire Court of Appeal. The frustrating thing about this petition for rehearing en banc is that it doesn't raise any new arguments, it doesn't raise any new novel ideas, it just rehashes Judge Wilkins' dissenting opinion and Judge Gleason's argument as laid out in his amicus brief. Now, I am not going over all of the facts in this case. It is a novel, or at the very least a playlist, which I'm going to link right here, the Michael Flynn playlist. You will get the rundown from the beginning to the present date. I am just going to do an overview, a very cursory overview of the procedure so you know where things stand. Michael Flynn was charged with lying to the FBI, and he ended up pleading guilty to one charge of lying to the FBI. He pleaded guilty and confirmed his guilty plea to 2 judges, including Judge Emmett Sullivan, under penalty of perjury. When he pleaded guilty, he was being represented by counsel that was arguably in a material conflict of interest as relates to representing Michael Flynn. He changed counsel, and his new counsel found multiple material Brady disclosure violations and sought to withdraw his guilty plea. Flynn's new attorneys obtained communication of evidence which proved FBI misconduct to say the least and FBI entrapment at the very worst. In light of this newly disclosed information, Michael Flynn sought to withdraw his guilty plea. The Department of Justice made a motion to dismiss the criminal information against Michael Flynn, which is basically a motion to dismiss the charges, and Judge Sullivan, who in the ordinary run of things is supposed to grant that motion, did not grant that motion. Not only did he not grant that motion, but he self-appointed an amicus to the file to present arguments in opposition to the Department of Justice's motion to dismiss. And who was that amicus? Judge John Gleason. Judge John Gleason, who a couple months earlier wrote an op-ed in the Washington Post entitled "The Flynn Case is Not Over Until the Judge Says It's Over." Not only did Judge Sullivan appoint an amicus, not only did he appoint this amicus in particular, to propose arguments in opposition of the Department of Justice's motion to dismiss, he asked that amicus whether or not Michael Flynn should not be held in contempt of court for perjury, for lying when he pleaded guilty to that which he's now pleading innocent to. People always say you can't make this stuff up. You could in fact make this stuff up. It's just that nobody would believe it if they didn't actually witness it in real time. The appointment of the amicus to contest an unopposed motion to dismiss the charges shocked pretty much everybody, and Michael Flynn's attorneys filed a petition for writ of mandamus ordering Judge Sullivan to grant the Department of Justice's motion to dismiss. Before the hearing on Michael Flynn's petition for writ of mandamus, amicus Gleason filed his amicus brief. The Court of Appeal heard the arguments on the petition for writ of mandamus, and they rendered their decision granting Michael Flynn's petition for writ of mandamus, ordering Judge Sullivan to grant the Department of Justice's motion to dismiss. The majority decision was detailed, meticulous, and it spent as much time responding to Judge Wilkins' dissenting opinion as it did addressing the arguments as a whole. And just when you thought Michael Flynn was a free man to go enjoy the remaining years of his life, true to form, Judge Emmett the Terminator Smith filed a petition for rehearing en banc because he was not happy with the Court of Appeal's majority decision. And what can I say? We're going to go through it, but it doesn't raise any new arguments that we already have not seen either in the amicus brief or in the dissenting appeals decision. Petition for rehearing en banc by Judge Emmett Sullivan. Introduction and Rule 35b(1) statement. And before we go any further, it's probably going to be useful to read the Rule 35b(1) because it is relatively interesting. Rule 35 en banc determination. When hearing or rehearing en banc may be ordered, a majority of the circuit judges who are in regular active service and who are not disqualified may order that an appeal or other proceeding be heard or reheard by the Court of Appeals en banc. An en banc hearing or rehearing is not favored and ordinarily will not be ordered unless 1. En banc consideration is necessary to secure or maintain uniformity of the court's decisions, or 2. The proceeding involves a question of exceptional importance. B. Petition for hearing or rehearing en banc. A party may petition for a hearing or rehearing en banc. 1. The petition must begin with a statement that either A. The panel decision conflicts with a decision of the United States Supreme Court or of the court to which the petition is addressed, with citation to conflicting case or cases, and consideration by the full court is therefore necessary to secure and maintain uniformity of the court's decisions, or B. The proceeding involves one or more questions of exceptional importance, each of which must be concisely stated. For example, a petition may assert that a proceeding presents a question of exceptional importance if it involves an issue on which the panel decision conflicts with the authoritative decisions of other United States courts of appeals that have addressed the issue. That is the procedural framework. Now let's get into the petition itself, which really is nothing more than reiterating the arguments of Judge Wilkin in the dissenting opinion and Judge Gleason's arguments in his amicus brief. The panel majority granted the extraordinary writ of mandamus to prevent the district court from receiving adversarial briefing and argument on a pending motion. The opinion is couched as a fact-bound ruling based on, quote, the record before the district court, end quote. It in fact marks a dramatic break from the precedent that threatens the orderly administration of justice. As far as I am concerned, this petition is so filled with projection it is oozing out of the four corners of the paper. A lot of people might say that it is exactly what Judge Sullivan has done that has threatened the orderly administration of justice. The Court of Appeals said as much in their majority decision. First, the majority undermined the court's consistent interpretation of the mandamus standard by forcing the district court to grant a motion it had not yet resolved based on alleged harms to a party that did not seek mandamus, and in reliance on arguments never presented to the district court. Any one of these rulings would constitute an unwarranted dilution of the requirement that a petitioner lack adequate alternative remedies. Taken together, they threatened to turn mandamus into an ordinary litigation tool. Second, the panel undercut Supreme Court and circuit precedent in holding that the separation of powers precluded the district court from inquiring into the government's Rule 48 motion. You will notice that Judge Sullivan systematically misrepresents the actual issues here. Nobody was preventing Judge Sullivan from inquiring into the Rule 48 motion, and what Judge Sullivan did was by no means inquiring. He single-handedly picked an amicus to oppose the Department of Justice's motion to dismiss, set up an entire schedule briefing, and suggested to the amicus that he look into charges of contempt of court for perjury. Some might argue that it is disingenuous and borderline intellectually dishonest to characterize that type of conduct as inquiring into a Rule 48 motion. Third, the panel contravened Supreme Court and Circuit Court precedent in precluding the district court from appointing an amicus and scheduling a hearing. The Supreme Court and this court have employed those practices to resolve cases where the parties agreed and the ultimate outcome was predictable. The panel cited no law precluding district courts from similarly considering both sides of an issue before deciding it. All arguments that were already presented to the Court of Appeal and specifically addressed in their opinion. The panel's decision threatens to turn ordinary judicial process upside down. And I am trying not to gag on the projection. It is literally Judge Emmett Sullivan who turned the entire judicial process upside down through his own conduct. It is the district court's job to consider and rule on pending motions, even ones that seem straightforward. And this is arguably a judicial admission to the effect that the Department of Justice's motion to dismiss was in fact pretty straightforward, and then it's going to be a question of determining whether or not faced with such a straightforward motion, the thing to do is to appoint an amicus to oppose the DOJ's arguments and to present arguments as to whether or not Michael Flynn should be held in contempt of court for perjury. Is that the proper and proportionate response to a straightforward motion, or is what Judge Sullivan doing turning the judicial system upside down as he's accusing the others of doing? And while we're on the subject of disingenuous mischaracterizations, let's just see how Judge Sullivan summarizes the factual background. On December 1, 2017, Mr. Flynn pleaded guilty before Judge Contreras to a one-count information charging him with violating 18 U.S.C. Section 1001. The case was then randomly reassigned to Judge Sullivan, who accepted Mr. Flynn's plea a second time. In June 2019, Mr. Flynn moved to dismiss based on purportedly Brady violations. The government opposed. After substantial briefing, Judge Sullivan denied the motions. On May 7, 2020, the government sought, quote, leave of court, end quote, to dismiss the information under Federal Rule of Criminal Procedure 48A. Mr. Flynn consented. Given the case history and the absence of adversarial briefing, the district court appointed retired federal judge John Gleason as amicus to present arguments in opposition to the government's motion and advise whether contempt proceedings should be initiated. The court set a briefing schedule and a hearing. Neither the government nor Mr. Flynn challenged those actions in the district court. Well, that's a very nice summary of what happened, but you know what's acutely missing from that summary? All of the evidence of the FBI misconduct. The text messages, the notes that basically show that the FBI effectively sought to entrap Michael Flynn. All of the evidence that the prosecution effectively coerced Michael Flynn into pleading guilty by threatening to investigate his son. You know, minor details missing from Judge Sullivan Sullivan's summary of the facts. Judge Wilkins dissented, concluding that the majority, quote, grievously overstepped, end quote, its jurisdiction by granting mandamus, quote, without first giving the lower court a reasonable opportunity to issue its own ruling or, quote, even hold a hearing. A tired argument that was specifically addressed. What Judge Sullivan did was not merely hold a hearing. Judge Sullivan basically went nuclear, appointing his own amicus, telling the amicus to oppose the DOJ's motion, and telling the amicus what to look into in terms of additional charges not already in the court record. The dangers in building a straw man is that they burn down very easily. Ooh, that is so good. Judge Wilkins added that this court had never before granted mandamus, quote, based on the absence of alternative avenues of relief for a different party that did not petition the court. Another tired argument that was also specifically addressed. There was the argument that Michael Flynn was the one who had to prove the irreparable harm and not the government, and in any case the government didn't file a petition for writ of mandamus. And the Court of Appeal concluded that the irreparable harm is not only relevant as far as Michael Flynn is concerned, it is relevant as far as the administration of justice as a whole is concerned. And what Judge Emmett Sullivan was doing was causing irreparable harm to the administration of justice as a whole. Further on in his petition, Judge Sullivan, through counsel, and remind me to get back to this at the end of this vlog, writes as follows. Here the majority granted mandamus based on the district court's amicus appointment and decision to hold a hearing. But neither Mr. Flynn nor the government asked the district court to reconsider those actions, notwithstanding the district court's express reminder that they could do so. Here Judge Sullivan is raising the argument that because Michael Flynn and the Department of Justice did not object to the scheduling of a hearing at the time Sullivan scheduled the hearing of the amicus, they are precluded from relying on that in support of the petition for writ of mandamus. And again, that sort of mischaracterizes the actual underlying argument. The argument is not that Flynn and the DOJ are saying issue the mandamus because Judge Sullivan issued a hearing on the amicus. The argument is that when Judge Sullivan says, whoa, I haven't decided anything yet, you have no business issuing the mandamus, the argument is that yes, you have in fact decided a lot. You scheduled a hearing, you told the amicus what to look into, you added issues that were not already on the table. It is grossly inaccurate to say that you haven't decided anything. You have decided a lot, and these are among the things that you have decided, which is why we have to issue the mandamus. Again, another tired argument that was already raised and already specifically addressed. Each of these departures from precedent threatens to expand mandamus beyond its properly circumscribed role and to invite the use of mandamus as foreign shopping where parties ask this court to decide issues in the first instance. The full court's review is necessary. And again, I am trying not to gag on the projection. Judge Sullivan is now accusing the Court of Appeal of expanding the scope of the mandamus when it was exactly Judge Sullivan who expanded the improper leave of the court as relates to applying a Rule 48A dismissal. And that was the bulk of the Court of Appeal's argument, that Judge Sullivan effectively went rogue. He became the judge, jury, executioner, prosecutor. He became everything all in one person. It was Judge Sullivan who improperly expanded the power of the court under the Rule 48A to effectively turn the judiciary into the executive, to turn the judge into the prosecutor. It was Judge Sullivan who did all of this, not the Court of Appeal in issuing the mandamus. The majority's reasoning also fails on its own terms. The district court's appointment of a, quote, private citizen does not distinguish this amicus appointment from the above examples. And the fact that the district court requested arguments, quote, in opposition to the government's motion simply reflects the procedural posture of the case. Well, that's Judge Sullivan's opinion, and the majority of the Court of Appeal already addressed it and disagreed. And saving the best for last, the most gag-worthy statement of the entire petition reads as follows. Conclusion. Judicial decisions are supposed to be based on the record before the court, not speculation about what the future may hold. This coming from the very judge who literally appointed his own amicus to act as prosecutor and even added questions to the debate that were not already before the court. This is literally chasing windmills that the Supreme Court warned against. All the district court has done is ensure adversarial briefing and an opportunity to ask questions about a pending motion. If that is really all Judge Sullivan thinks he's done, well, we have a difference of opinion, and I prefer my opinion to his because I think mine is supported by actual facts and evidence. Sullivan had every opportunity in the world to hold a hearing and ask his questions without appointing his own amicus to specifically oppose the motion to dismiss and to adjudicate on questions of perjury and contempt that were not already before the court. This is such an egregious mischaracterization of what Judge Sullivan's done that it causes him to lose any credibility that he may have had left. Considering both sides of an issue before ruling is not ultra-virus, it is sound judicial practice. The petition for rehearing en banc should be granted. And again, if Judge Sullivan thinks that all he was doing was considering both sides, well, I like my opinion a little more. Judge Sullivan was not considering both sides, he was actively arguing one side. He was actively arguing one side through a self-appointed mouthpiece in whom he was planting the questions to be asked. And just to come back to and end on something that I had mentioned earlier, just look at the lawyers involved in this case for and on behalf of Judge Sullivan. Now, I don't know if all 4 lawyers had a hand in drafting this petition, but nothing is too good for Judge Sullivan, and you may recognize the name Beth Wilkinson because she in fact represented Cheryl Mills, Hillary Clinton's aide. And who is paying for this? Not Judge Sullivan, that much is for certain. This is paid from your taxpayer dollars. Judge Sullivan has no skin in the game, so he's got nothing to lose by making this petition for rehearing en banc. And that is the unfortunate reality of litigation. When you are not paying for your own attorney, it changes the nature of the game, much in the same way playing poker with someone else's money changes the way you would play poker. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got merch, PayPal, Subscribe Star, YouTube membership, Patreon. Everybody who supports the channel gets sneak peeks to the videos in as much as possible. But above all else, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah.